Hi, this audio recording will be discussing defenses to negligent claims. First, we're going to look at defenses against liability or a tort action. There's some defenses based on common law. And again, common law is the law that's developed through the court system. So these defenses are based on court hearings and decisions that have been made over time. We're going to look at the assumption of risk defense. We're going to look at the immunity defense, and we're going to look at ultra vires acts, which are all defenses based on common law decisions. An assumption of risks. For an assumption of risk, somebody has to know, appreciate, and understand the inherent risks to the activity. Again, it's inherent risks. When you think of assumption of risk, think of inherent risks. It's a risk that is associated with the activity itself. A person has to know the risk and voluntarily assume that risk. So we're going to look at different types of either express or implied assumption of risks. With an express assumption of risk, that is when we get it either oral or in writing. For example, we may write down, due to participation in this sport or activity, you may incur the following types of injuries. By agreeing to this type of physical therapy, these type of injuries may occur. So it is an assumption of risk. I know, appreciate, and understand that inherent risk, but I still choose to do it. An implied assumption of risk is when a person has participated in the event and they know and they understand the risks, and yet they continue to participate in it. As we look at one of the cases that is typically assigned in discussed as a whitewater activity, whitewater rafting, we can see a very specific implied assumption of risk where somebody has known and appreciated the risk but still decides to participate in the activity. Sovereign immunity is a common law defense. In sovereign immunity, a governmental immunity is also a similar action. A governmental or a specific sovereign person cannot face that type of negligent action without their consent. For example, there's a certain number of crimes that people from other countries, if they're here on diplomatic immunity, are allowed to do. I know people in New York City are frustrated with certain diplomatic immunity with parking, that a car with diplomatic plates is allowed to park in certain areas that otherwise people wouldn't, or they would get ticketed. As we look at some of our cases, we'll see that somebody may be, in fact, should be liable for their actions, but because of their governmental place, maybe they are a certain category, they do not face that liability because of immunity effects. Or an ultra vires act is a defense that a corporate entity may use because the actor was not within the scope of responsibility or authority, that the corporate entity or organization should not be held liable for the actions of their employee because the employee did it while frolicking upon their own affairs, not within their job description. Smith versus Gardner discusses this type of defense. It's similar to a respondeat superior, kind of the flip side of it. We can have defenses made on contract law. We'll look at waivers, informed consents, agreement to participate, and indemnification agreements. We'll look at defenses based in statutory law, like contributory negligence or comparative negligence, and some sort of immunities based on statutes and a statute of limitations. Contributory negligence. This is conduct by the plaintiff that in some way contributes to their injuries. Only 2 states still recognize contributory negligence, where if the plaintiff is found to contribute at all to the injury, they're completely barred from plaintiff recovery. Most jurisdictions use comparative negligence. Comparative negligence allows a plaintiff who is somewhat responsible for their own injuries to still collect damages. However, that damage award will be prorated. For example, if I go to a physical therapist and due to some sort of negligent activity, the physical therapist caused injury to me. If I am found to be comparative negligence, if my behavior contributed to it, if for instance, I didn't explain to the therapist that my hamstring was hurting and somehow that impacted the injury. A jury could find the percentage of responsibility for each group. Maybe they say that by my not telling the therapist of my injury, that contributed 25% to the overall injury. For $1 million ruling, then the damages would be discounted 25%. So instead of receiving $1 million in damages from the physical therapist, I would receive $750,000. The $1 million award subtracted the 25% that I was a part of that could be blamed on myself. There are two types of comparative fault. One is pure and one is modified. The pure is like I discussed right there with the percentage of fault assigned to the plaintiff at a certain percentage. A modified says that if a plaintiff is 51% liable for their own activities, if instead of 25%, a judgment came back and they said that I was 51% liable because it is not substantially, then in fact I would not recover anything. Statute of limitations is a area that says there's only a certain amount of time allotted to bringing a lawsuit to courts. You can't wait forever before you bring it. Typically for torts, it is 1 to 4 years from the date of injury. So once you get injured, you need to be able to find out what that injury is, who is liable for it within 4 years at a maximum in order to bring that lawsuit to court. Immunity is another defense. Immunity is a major category that individuals and service providers would be immune. They would not be considered liable for the actions of others. This could be sovereign immunity that we looked at and discussed a second ago, charitable immunity, recreational users, sport volunteers, good Samaritans, or statutory assumption of risk. Looking at these types of immunity actions, a good Samaritan is a kind of well-known type of immunity that if you provide first aid or help to another person, then it is not logical to allow that person to bring a lawsuit against you in case you harm them in some way. Charitable immunity, recreational user. If somebody opens up their property for others to come and use it for recreation purposes, to run on or to ski or to ice skate, this is a way to protect those types of facilities to be open without allowing them to be up and face against a lawsuit. For recreational use, it's typically a private landowner that use some sort of underdeveloped land and does not charge a fee for people to use the property to run on, to skate on, to snowmobile on. In exchange for that recreational use, we are going to protect that landowner from a lawsuit. A waiver is a contract defense, and this contract defense allows a participant or creates the situation where a participant, by signing the waiver and participating in the activity, they will agree not to bring a lawsuit against the service provider for ordinary negligence. Difference between waivers and assumption risk documents are very important, even though most of the time they're referred to the same thing. People will call them all waivers. But an assumption risk document deals with inherent risk. We are acknowledging that the participant knows, appreciates, and understands the inherent risk of the activity. A waiver is a contract that absolves negligence. So they're very different aspects. One deals with inherent risk, the other deals with negligence. So a waiver basically says, when you sign this contract, that you are now absolving me from my duty to protect you from unreasonable risk and harm. It's very different. Most organizations will have both an assumption risk and a waiver. We commonly refer to them both as waivers. However, be clear that the assumption risk is inherent risk, and a waiver really is kind of powerful. A waiver is saying, by participating in this, if you've done something wrong to me, if the service provider fails in their duty to protect me from unreasonable risk of harm, I will not bring a lawsuit against them. In at least 43 states, a well-written waiver voluntarily signed by an adult will protect the service provider from liability for ordinary negligence. It's based in contract law. Guidelines for waivers. The title of the waiver should be very descriptive. It should say the word waiver. It should say the word negligence. So people signing this contract will know exactly what they are signing away. It is a contract. And we'll get into all sorts of contracts in a couple of weeks, but it has to be clear language. It should be one page. It should be conspicuous. It should be detailed. If it's in a part of a larger contract, you may want somebody to initial it. You want people to be able to see this waiver and understand what they're signing away, so that if a lawsuit does occur, your evidence would be able to say, here's my waiver, see the way due to its content and its context, people should understand what they are signing away. The context, the size of the waiver, the print size, how it looks, it can't be multiple pages, is important. The content, what it is saying, specifying the parties, saying what rights they are getting rid of. So we're looking at many different areas of this idea, content and context of a waiver. As a general rule, waivers are not enforceable against minors because minors are not allowed to sign contracts. However, in most states, and becoming more common, parental waivers are being allowed to sign for their students to waive rights to bring that lawsuit for their kids. Here's a map that shows a little bit of detail of states that allow waivers and states that really don't like waivers. Again, because it's state law, states can interpret this very differently. You may see a state like what does it look like? Virginia, Louisiana, and Montana, where waivers are not enforceable at all. So we're not going to allow a service provider to completely get rid of their responsibility or their duty to the participants that they are charging money for. Other states are very lenient. Some states are rigorous, where we'll allow waivers. However, they have to be written in a very certain way, the content and the context. Here's an example of New York, which is considered rigorous. Although disfavored by law and closely scrutinized by courts, they're generally enforceable. So it shows you the courts really don't like the idea that we're getting rid of the requirement of somebody providing a duty to protect other people. However, because it's a contract, we will allow it, but it has to be written in a very specific way. It has to be clear and coherent. Risks are not assumed if they're not detailed within that document. The language of the agreement must express in unequivocal terms the intentions of the parties to relieve the relying party of liability for negligence. The word negligence or words conveying the same import, such as caused by the neglect or fault of the relieving party, must appear in the agreement. So this is really showing that courts in New York will accept waivers, but they don't like to. And if there's a reason for them not to, then they won't. Stokes versus Ballys is a great case that shows what a waiver may or may not be able to cover for a service provider. Informed consent or agreement to participate. Inherent risk. These are your assumption of risk documents. All states recognize the participant assumption of inherent risk as a strong defense. So an inherent risk isn't able to be recoverable in a lawsuit, these documents are showing that you have given consent to face those inherent risks. Informed consent, they could be medical treatment, they could be an inherent right to control what happens to your body, or fiduciary duty to make a patient, to warn a patient of risks, or make sure the patient knows to make informed decision providing their care. So we have a lot of medical aspect. Here's my informed consent agreement. You are allowed to perform this type of activity on me. Or if I go in for rehabilitation, or if I'm doing some sort of fitness, or if I'm going into a doctor, I look at this medical informed consent and I begin to understand what exactly somebody will be doing to me. So that at the end of the day, somebody can't bring a lawsuit and say, well, I went through this physical therapy aspect and I didn't realize that they were going to move my back so much. Now I have pain and suffering in my back. Well, oftentimes rehabilitation causes injury. It will be more helpful and you'll be able to recover from it, but rehabilitation, oftentimes hurts and is painful in order to get a person healthy. So an informed consent will show the plaintiff and the court that this person did know what would be happening. They did know the inherent risks and potential outcomes of it. So we're looking at injury rehabilitation programs, fitness testing, fitness regimens, physical trainers, physical therapists, occupational therapists, all these different service providers, which are growing in numbers across the country in terms of employment, are utilizing informed consent in order to protect themselves against potential lawsuits. An agreement to participate is not a contract, is very similar to that assumption of risk. It just shows a person the inherent risks and the expectations of the participants, and allows them to sign that they know, appreciate, understand the activities that they're about to participate in. So here you're looking at the nature of the activity, you're looking at the risks involved, and the behavioral expectations of the participant. Here is a document. It's not a waiver. It does not a contract. It does not absolve negligence. It is inherent risk. It's showing that the participant knows the activity, knows the risks, and here is what we expect you to do. The agreement, like I said, talks about the nature of the activity, possible consequences of the injury, my expectations. Perhaps it's skydiving. The nature of the activity is skydiving. You're going to be jumping out of an airplane at 5,000 feet, and possible consequences may result in hurt, injured ankles, maybe broken leg, may even be death. My expectations are that you will follow all instructions of personnel, that when you jump out, you will pull the ripcord at a certain point, that you will land. So somehow we look at the behavioral expectations. We talk about the condition of the participant. We've seen this, that I certify that I am in proper medical condition and the right kind of medical health in order to face this type of activity. Sometimes we see this when we go to amusement parks. We'll see an assumption of risk or contents of this agreement that says, in order to participate on this roller coaster, all riders signify that they are free from back injury, they're not pregnant, that they don't suffer from vertigo, and they'll list a couple of specific conditions that the rider, by choosing to participate, inherently agrees to those conditions. So this agreement to participate has two major purposes. One, it establishes a primary assumption of risk, whether it's express or implied. If it's express, it's written down. You can get oral affirmation from it. If it's just written and people walk through, then it could be the implied that they know it and still continue on. They establish participation was voluntary, and they're aware, they know, appreciate, and understand. And that's a very specific legal term, know, appreciate, and understand the inherent risks. It also helps with a secondary assumption of risk, sometimes contributory fault, that shows that the participant knew the expected behaviors and agreed to adhere to them, and they in fact didn't. So we look at the agreement to participate and we see that it brings a couple of benefits to us. The assumption of risk agreement is a pact by which the participant is informed of the inherent risks of the activities and attests that he or she assumes the inherent risks of that activity. The person has been informed of its inherent risks. The person understands the activity in terms of the demands on the own physical condition skill level and appreciates the types of injuries that may occur. Knows, understands, and appreciates. And finally, the participant or client verifies that his or her participation is voluntary. It can be a standalone document, but is often and should be included as a part of liability waiver. So with the assumption of risk, you're covering inherent risks. With the waiver, you're covering negligence. Regardless of the form, the assumption of risk agreement applies to the assumption of inherent risks and offers no protection against liability for provider negligence. That would be the waiver. And as we saw a few minutes ago, depending on our state, really shows what type of scrutiny the courts will have with the waiver. Will they allow it? Will they not allow it? If they do allow it, what type of terms and conditions are there? And then finally, we can look at Fairchild versus Edmondson as a case to really flesh out these differences of waivers and assumption of risk documents. I hope this made defenses to negligence a little more clear. Thank you.